has submitted that the appellant may be granted some time to ascertain the correct address of the respondent number 6 and thereafter take steps for issuance of notice on the respondent number 6. First, you will assess the address. We are fixing it shortly after. You let the court know about the correct address.
Okay.
Then we will pass orders for issuance of notice. The appellant is allowed to ascertain the correct address of the respondent number 6 and let this court know about the correct address of the respondent number 6 on the next date fixed. Let this case be listed again on after 2 weeks. After 2 weeks, on a date to be fixed by registry.
Not eligible. So, sir, this matter may come up for 1 week lordship. Also, we will have to file the substitution petition also.
Substitution petition. What is this I have for?
I was for restitution
Restore.
487.
This RSA was dismissed.
Others, sir, this is for no prosecution.
At times, RSA is difficult. Substitution petition is also difficult.
This is the second substitution petition.
Second substitution. Thereafter also now.
Okay, let them take steps. Who expired?
Applicant number 1,
1, 3, and 7.
1, 3, and 7.
1, 3, and 7. Who is Kanti Ramnath? He was the original
This original
defendant.
defendant and not.
Now the second appeal has been preferred by the defendant.
I'm not defendant.
Heard Mr.
Nath.
A. Nath, learned counsel for the appellant. Also heard Mr. F. What is F.U. Borbhuya, learned counsel for the respondents. All the respondents. Learned counsel for respondent. Who is for the respondent number 2? Respondent number 1, stop. Learned counsel for the applicant / appellant has submitted that the applicant number who has expired?
1, 3, and 7.
1, 3, and 7.
1, 3, and 7 have expired, and therefore he seeks some time to take appropriate steps for substitution of the legal representatives of the aforesaid applicants, and seeks how much time? 1 week time for the same. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Made this is your lordship. Lordship, here we were asked to take steps by both ways, but inadvertently we had taken only by usual process and not registered AD. But Lordship, office note dated 26/7/24 does not reveal anything about the service. Lordship, on respondent number 3. 1 and 2 already served. Only 3 was left, Lordship. अपनी नॉलेज करना अपने फोन नंबर से
Respondent number one.
However, inadvertently, the appellant could not take the steps by the registered post with AD and hence prays for some more time. Hence, she prays for some more time for taking steps accordingly. The prayer is allowed.
On respondent number 3, Lordship.
The it appears from order dated 4/11/2022 that notices on respondent number 1 and 2 are already complete. Hence, the appellant shall take fresh steps for issuance of notice on respondent number 3 by registered post with AD within, as well as by usual mode also.
No, usual mode, Lordship, registry will confirm because nothing has come. So registry will, Lordship will direct the registry.
By registered post with AD within 7 days from the date of this order, returnable on 24th of September 2024. The office shall confirm, office shall put a office note on the next date fixed regarding the fate of the notices issued to respondent number 3 by usual mode. List accordingly.
Highly obliged, Lordship.
Obliged, Lordship.
একটু flag করে দিতে হবে। ফাইলে দিবি। Yes.
Lordship service is completed except 7 and 8 as per Lojima Court order dated 18/7/24.
My lord, I am appearing for respondent number 1, 2, 3, and 4.
1, 2,
3 and 4.
3, 4, 7, 4
35
responded, 7 and 8 as I have served copy of the petition to the standing council.
35, how many are going to Seven and eight.
You- Anybody has appeared for respondent number 7 and 8? Anybody is appearing? No. You
I am appearing for 5 and 6, Your Lordship.
5 and 6. You file an affidavit that you have served a copy of notice to 7 and 8.
Today I served that.
No, you file an affidavit mentioning therein that you have served the notice on the standing council of 7 and 8. Then we will deem it proper service. Okay,
Yes, my lord, except 7 and 8, service has been
Service.
completed.
let them file an affidavit. Heard, Miss, what is your name?
Ashal,
Heard, Miss S.
Tahi,
Sahi, Learned Counsel for the petitioner. Also heard Mr.
S.M. Borua,
S. M. Borua, appearing for respondent number
1, 2, 3, and 4.
1, 2, 3, and 4. Stop. Also heard Miss
K. Fukan,
K. Fukon, appearing for
respondent number 5 and 6.
respondent number 5 and 6. Learned Counsel for the
Government, Your Lordship.
learned 5 and 6, learned government advocate. Stop. Learned Counsel for the petitioner has submitted that she has served the notice in respect of respondent number 7 and 8 to the standing council of the respondent number 7 and 8. And praise some time to file an affidavit to that effect before this court.
Respondent
The prayer is allowed. Let this matter be listed again after a week. Within a week you file, then we will proceed to next steps. Let this matter be listed after a week.
Much obliged.
May it please your lordship. Lordship, as per office note dated 2/8/24, notice in respect of respondent number 1 was received by the respondent number 2, my lord. And here the respondent number 2 is the father of respondent number 1, lordship. So service may deem to be complete.
Now, whether these matter goes to Lawajima court or not, service matter. The what is your submission?
Lordship, service may deem to be complete, my lord. Because respondent number 3 has already appeared and respondent number 2 has been represented by their counsel, my lord. They have also filed wakalatnama.
How many respondents are there?
3 respondents, lordship.
And one
My lord,
and one as
Uh,
regards this.
as regards the my lord, the notice which was issued to respondent number 1 that was received by the respondent number 2, my lord.
Heard Mr. M. Zaman, Learned Counsel for the appellant.
Lordship, in this case, I'm appearing on behalf of Mr. M. Ahmed, my lord. He has some difficulties, so
Who
he
is
had to
appearing?
leave the.
M. Zaman, who is appearing for Mr. M. Ahmed, Learned Counsel for the appellant. Also heard Mr. A. J. Soikia, appearing for respondent number 3. On perusal of the office note dated 2/8/2024, it appears that the notices sent to respondent number 1 and 2 have been duly served And engaged counsel of respondent number 2 has also filed his wakalatnama. LCR I sent. The record of MAC case number 136/2017 has been received from the concerned tribunal. As the service on the respondent is complete, this case is ready for hearing. Let this case be listed for hearing after 4 weeks on a date to be fixed by registry.
Obliged, Lordship.
After lunch.
Wait, please, Your Lordship.
What is this?
Lordship, this is a this is a application under 227 Lordship. Lordship may produce the last judicial order wherein Lordship actually on that day my submission was due to some inadvertence. This application was previously filed under section 115, but this will not be under section 115 of the CPC. This will be under 227. So accordingly, leave was granted to me to file the fresh clause title page. Accordingly, I have done, and this has come up for the first time after that. Lordship, the issue over here is very small, Lordship.
Whether it has been registered as
Yes, it has been registered as CRPIO.
what is the issue?
Lordship, the issue over here is very simple, Lordship. There was an title suit.
Whether notice will go to the
Lordship, there are two respondents. One is Shaukat Ali and the second respondent is Labu Mia. Labu Mia was represented on the last few occasions by Mr. S.C. Kayal. Last time also he was present. Today, I don't know why, maybe he is absent or whatever. And Lordship, in regard to respondent number 1.
that was he appeared in interlocutory application only.
But now, Lordship, as because it has been changed from 1152 to 227, interlocutory application goes.
Now we have to issue fresh notice in this case. Because in this case, there is no appearance.
In that case, Lordship, because the item was, sorry, Lordship, this matter is very old pending one, and the issue is very, very limited.
Still, other side has to be heard.
I can call him if Lordship grants me some time, whether if he appears, then the matter will be heard today and disposed of. After some time, 5 to 10.
I think I don't know,
Made to your lordship. Lordship, this is an MSC appeal by the insurance company, lordship. Lordship, here, lordship, the ground is that involvement of the vehicle insured with us, lordship, in the accident. Because what happens in this case, lordship, there were 3 FIRs filed by 3 different individuals against 2 different individuals, lordship. And the charge sheet was laid down on the basis of the 3rd FIR, lordship, which was filed against us. The previous 2 FIRs were filed against some other vehicle, lordship. And those 2 FIRs were amalgamated, lordship, with the last one, lordship. And that is how the charge sheet has been filed. And on the basis of that charge sheet, lordship, award has been passed.
Is it a death case or
This is an injury case, lordship.
injury case?
In fact, there are 3 cases which are pending before the Honorable Court, lordship. 3 appeals.
What happened to other appeals?
Lordship, there is a stay order in the other appeal, lordship.
Okay. Heard Mr. T. Kolita, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant insurance company, impugning the judgment and award dated 29/10/2022, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro at Guwahati, in MAC case number 1951 of 2017, whereby the present appellant were directed to pay a compensation amount of rupees
Lordship, here, lordship, the amount was 1,47,403.
1,47,403 to the opposite party, to the claimant respondents. Issue notice to this appeal is admitted. Stop. Call for the case record of MSC case number 1951/2017 from the concerned tribunal. Stop. Registry to take steps for requisitioning the aforesaid case record. The appellant shall take steps for issuance of notice to the respondents on by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 24th of September 2023. 24, list accordingly.
Lordship, may I beg to interrupt, lordship. The respondent number 1 has appeared. Their name has been shown in the cause list, lordship. Respondent number 1.
No, today nobody has appeared. You take steps.
Lordship.
Let us see on the next
Sorry.
page. In interlocutory application, let them appear or you pay 50%.
Lordship, since it's a case of involvement, lordship, because the connected appeal, lordship, I have placed the order. It was passed in the IA, lordship.
Mhm. You have to pay 50%. It will remain deposited in the
So
registry.
that may not be allowed to be,
Without hearing you, we will not
lordship,
disburse it.
lordship.
Heard Mr. T. Kalita, learned counsel for the applicant/appellant. This application under order 41, rule 5 of the Code of Civil Procedure, Civil Procedure 1908 has been filed by the applicant for stay of the execution of the impugned judgment and award dated 29/10/2022, passed in MSC case number 1951/2017 by the Motor Accident Claims Tribunal number 3, Kamrup Metro, Guwahati. Stop. The said judgment and award has been impugned by the applicant by referring the connected MSc appeal number 264/2024. Learned counsel for the this is analogous case,
Lordship, but out of the
same accident,
accident,
Learned
it was passed in their presence only, Lordship.
learned counsel for the applicant has submitted that in a connected MSc appeal which arose out of the same accident, a coordinate bench of this court has stayed the operation of impugned judgment and award in that case, and hence the counsel for the appellant has prayed that in the instant case also the execution of the impugned judgment and award may be stayed. Stop. Considering the submissions made by learned counsel for the appellant and considering the nature of relief sought for in this interlocutory application, the notice to opposite party in this interlocutory application is waived. Stop. The prayer for stay of the execution of the impugned judgment and award is hereby allowed, subject to payment of 50% of the awarded compensation amount by the applicant to the registry of this court within a period of
6 weeks.
6 weeks from the date of this order. Stop. It is hereby made, it is hereby made clear herein that the deposited amount shall not be disbursed to anyone without hearing the applicant. This interlocutory application is accordingly disposed of.
Much obliged.
47.
May it please your lordship. Your lordship, in this matter, your lordship, as per the last order, services was complete on respondent number 1, 4, 5, and 7. Lordship. With regard to the other respondents, we were directed to take. Fresh
You have
steps.
not taken steps.
Yes, my lord, there has been inadvertent delay in that matter, my lord. I pray for 1 week time, my lord. We will take the steps within a week's time.
Is there any interim? No.
Interim? No, yeah.
Okay. Heard, Mr. What is your name?
A Das on behalf of A Sapien.
Heard, Mr. A. Das. Submitting on behalf of Mr. A. Chetia, learned counsel for the petitioner who prays for some 1 week time for taking steps for issuance of notice on respondent number 2, 3, 6, 8, 9, and 12, 9 to 12. The prayer is allowed. The applicant, the appellant, the petitioner shall take fresh steps for issuance of notice to the aforesaid respondents within 1 week from the date of this order. The notices are returnable on 24th of September 2024. List accordingly.
Hello.
Lordship,
Yeah.
in this case, out of 4 respondents, 1 and 2 is represented by my learned friend, Lordship. In respect of Lordship 3 and 4, Lordship, office note dated 37/24, so the respondent number 3A has refused, Lordship.
Refused.
Yes, Lordship. Office note dated, Lordship, 37/24. And 3B, Lordship, 3A and 3B, Lordship, same address, Delhi address, both are owners, co-owners of the vehicle lordship, but it is written that no such person. But this is the address where the trial court case was proceeded and we have taken a step. Why it is written lordship, I am not aware. And in respect of respondent 4 also, insufficient address it is written. So in respect of 3B and 4, I will have to take instruction what to do with the Delhi address.
As regards other respondents,
I am applying for 1 and 2 lordship,
Present lordship.
claimant lordship.
heard Mr. A.J. Soikia, learned counsel for the appellant. Also heard Mr.
K.R. Bora lordship.
A.R. Bora, appearing
Respondent
for
1 and 2.
respondent number 1 and 2. On perusal of the office note dated 30/7/2024, it appears that the unserved notices sent to respondent number 3 within bracket small a has returned with an endorsement within inverted comma refused. No such person.
Lordship 3A refused, 3B no such person.
3A refused. And in respect of respondent number 3B, 3 within bracket B, notices have returned with endorsement within inverted comma no such person. And in respect of respondent number 4, notices notice has been returned with an endorsement within bracket insufficient address. In view of above, the notice issued to respondent number 3 within bracket A is held to be duly served. As regards respondent number 3 within bracket B and respondent number 4, the learned counsel for the appellant has prayed for some more time to take necessary instructions as regards the proper address of the aforesaid respondents. The prayer is allowed. How much time will you require?
5 weeks. Lordship.
You will inform the court about the correct address. Thereafter, you take steps.
Yes, I will, Lordship, have to take instruction by company lordship. We will have to find out.
Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after
5 weeks.
5 weeks, on which, and on the next date, the appellant shall inform this court regarding the correct address of respondent number 3, B and 4. And stop, list accordingly.
May I please your lordship, another 2 analogous MSC appeal is pending same cause of action lordship. MSC appeal 417/2022 and MSC appeal 419/2022.
MSC appeal 4-1,
7/2022 and another is 417/2022.
one is 417/2022, another
Lordship.
one is
419/2022.
learned counsel for
Those
respondent.
matters may be like
Learned counsel for the respondent number 1 has submitted that in connection with the same accident, 2 more analogous
MSC appeal.
MSC appeals are pending before this court, namely MSC appeal number 417/2022 and MSC appeal number 419/2022. Registry shall list this MSC appeal along with the aforesaid MSC appeals on the next date fixed.
Okay,
Yes, sir.
Highly august, sir.
At time being at the yes.
Lordship, the applicant has filed, preferred an interlocutory application for recording the death of respondent number 1, 2, and 6, Lordship, along with the condemnation petition, Lordship.
But here, your lordship,
step
we have not been
was
served copies, your lordship.
Step was not completed, Lordship.
All
Therefore, that may be
the-
given to take fresh steps, Lordship.
All the IAs, your lordship. There are 4 IAs,
No, I number 712 is for what purpose?
condonation.
Condonation of delay, Lordship.
Notices are served on all the,
No, Lordship, step was not taken. Due to
We have not
difficulty,
proceeded.
the appellant could not come, Lordship.
Mr.
MHL.
M.H. Ali. Sop kita hai, eta order, common order, all eyes. M.H. Ali, learned counsel for the applicant. Also heard Mr. What is your name?
AM doctor,
A.M. Dutta, appearing for
all the respondents.
all the
Original respondents, your lordship.
this respondent number 1 to 6.
1 to 6.
Respondent number 1 to 6. Then there would be no necessity of issuing notice. Stop,
Extra copies will be.
No, extra.
as Mr.
AM doctor,
A.M. Dutta has appeared for all the respondent.
respondents 1 to 6, your lordship.
Respondent number 1 to 6.
Others are performed.
1 to 6, there is some substitution also.
Yes.
Yes, sir.
Because of there
Two.
the pendency, your lordship.
2 has
respondent
died.
numbers 1, 2, and 6 expired. During the pendency. of this.
1, 2, and 6.
1, 2, and 6
So are you appearing for their legal heirs also?
might be.
So what should we do? Should we issue notice to legal heirs or you are appearing?
Lordship.
Yes. Notices may be issued.
For learned counsel for the respondent has submitted that since the original respondent number 1, 2, and 6 for whom the counsel had appeared have already expired. Hence, he prays that notices may go to the legal heirs of legal representative of the aforesaid respondents. Stop, issue notice to the respondents, opposite party.
Lordship, the respondent number 6 died unmarried.
No.
There is no legal heirs, Lordship.
Okay, it will a bit. Since
One and two.
One and two.
since Mr. A.J. Datta has appeared for respondent number
AM doctor.
A.M. Datta has appeared for respondent number 3, 4, and 5. No formal notice need to be issued to the said respondents. As regards respondent number 1A to 1D and 2A to 2C, the applicant shall take fresh steps for issuance of notice on the said respondents by registered post with AD as well as by usual mode. Within a week from the date of this order, the notices are returnable on 24th of September 2024. The applicant is directed to furnish the copies of interlocutory application to Mr. A.J. Datta. List accordingly.
Lordship, in this case, while convention application, I paid for the respondents. Today, my name was not found, so I missed the matter. Lordship, I take up on Friday.
Lordship, we take it up on Friday, but the thing is, Lordship, he has appeared for respondent number 2. In the
One is expired.
one, respondent number 1,
He expired.
he has expired during the pendency of the lower court case. Lord.
Lordship, in the title suit itself. I have derived instruction from my client and got that he expired in 2015. But Lordship, I will not substitute his legal heirs for the fact that in the lower court, I mean, in the title suit itself, he was made ex parte. The suit proceeded ex parte for him. So I will strike off his name from this.
Whether
He is not
decree would be executed.
Yes, Lordship, because therein there was a compromise degree between the plaintiff and he was not a
You
party.
want it to be fixed on Friday.
Lordship.
Heard, Miss, what is your name?
Yes.
I Das, learned counsel for the petitioner. Also heard Mr. S.C. Kyal, appearing for
Respondent opposite
respond-
party number 2.
opposite party number 2, Labumia,
Lordship.
Labumia. You will make formal application for striking out the names or oral application.
Lordship, otherwise if it's as per your Lordship, that direction, Lordship.
No, I will not make any direction. You have to
Because
make
it's
submission.
required, Lordship, I'll just on
Learned
submission.
counsel for the applicant submits that the respondent number 1, Mohammed Shaukat Ali, has expired, has passed away, had passed away during the pendency of the
Title suit itself.
title suit before the trial court, and the suit proceeded ex parte against the said respondent. And therefore, she submits that his name may be struck off from the memo from the revision petition. The prayer is allowed. The name of Mohammed Shaukat Ali, respondent number 1 may be strike out from the revision petition, registry to do the needful. Learned counsel for the respondent number 2 submits that this case may be fixed for hearing on
Tuesday, Friday.
Friday, that is
9th.
9/8. The prayer is allowed. Let this case be listed again on 9th of August.
But see, my name may be shown.
The name of Mr. A.C. Kayal may be shown as the engaged counsel for respondent number 2 in the cause list henceforth.
Much.
Lordship, one thing, Lordship, today the matter has come up in the motion column. So if your Lordship has directed.
hearing.
Lordship.
Admission hearing.
Much.
Next date will be for admission hearing.
Made resolution.
Yes.
This appeal has been preferred against the judgment and award dated 13/6/2018.
Yes.
To your Lordship, the case proceeded ex parte against the appellant opposite party number 2 before the learned tribunal, your Lordship. And it came to their knowledge only when the recovery case has been initiated against them by the insurance company, your Lordship. And that was in 29/8/2019, your Lordship. After that, your Lordship, the present appeal has been filed and there is a delay of 550 days, your Lordship, that has been condoned on the earlier occasion.
Delay has been condoned.
Yes, your Lordship, that is IA number 103. That has been
Heard Mr. What is your name?
G. Bodley, your Lordship.
Heard Mr. G. Bordole, learned counsel for the. Somebody has appeared for respondents also.
Yes, for the insurance company, your Lordship, on the last occasion. They have-
Learned counsel for the appellant. None has appeared for respondent number 1 and 2, though the name of Mr. R. Goswami has been shown as the counsel for respondent number 1 and 2. This appeal under section 173 of the MD Act, 1988 has been filed by the appellant claimant. You were the
No,
claimant,
your Lordship, I was the owner of the vehicle.
appellant / owner of the vehicle involved in the accident namely Srimati Santana De, impugning the judgment and award dated 13/6/2018, passed by the Motor Accident Claims Tribunal, Gwalpara in MSC case number 58/2016. You were directed to pay,
Yes, your lordship.
whereby the appellant was directed to pay and
50% of the awarded amount.
50% of the awarded amount of rupees 5,59,000 to the respondents, claimant respondent. Stop. The appeal is admitted. Call for the case record of MSC case number 58/2016 from the concerned tribunal. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable on 24th September 2020. None appears for
Me, please, your lordship. Lordship, we have filed this IA for withdrawal of the statutory amount, lordship. The appeal has been disposed of.
Okay, heard Miss, what is your name?
M. Saikia, lordship.
Heard Miss M. Soikia, learned counsel for the applicant insurance company. This interlocutory application has been filed by the applicant insurance company who preferred, who had preferred the MAC appeal number 198/2012. The applicant has prayed for allowing the applicant/appellant to withdraw the statutory deposit of 25,000 made by the applicant/appellant at the time of filing of the aforesaid appeal. The prayer is allowed. The registry shall refund the statutory deposit of 25,000 made by the appellant/appellant at the time of filing of the MSC appeal number 198/2012 after proper verification. This interlocutory appeal is accordingly disposed of.
Obliged, lordship.
May I please, lordship? I am for respondent, lordship.
Make please your lordship. Lordship, there was some delay in filing this petition. So, the learned court needs order dated 24/4/24. Asked for some material information. Material information to be provided by the applicant against the, for the allegation that she was not informed by the learned trial court counsel on time. That's why the delay was, there was delay in filing this petition. So, and till now, we have not been informed by the petitioner, so some time may be needed.
No, what has not been informed?
The allegation that the petitioner had made against the learned counsel,
Earlier engaged counsel.
earlier engaged counsel.
Okay.
So some material evidence was to be provided, some material on record. So we have not been informed till now.
Heard Mr. M. Das Gupta, learned counsel for the applicant. Also heard Mr. S. Deori,
Yes, lordship.
learned counsel appearing for
Respondent number 1 and 2.
respondent number 1 and 2. Learned counsel for the applicant has submitted that this court by order dated 24/4/2024 had directed the applicant to provide necessary materials on record against the allegations made by the applicant against his or her her earlier engaged counsel. However, stop, earlier engaged counsel, stop. However, learned counsel for the applicant has submitted that some more time is required as some more time is required for the same as the applicant is unable to what? Collect
Collect the information or provide, inform us.
unable to inform the counsel for the applicant regarding the materials on the basis of which allegation against the earlier engaged counsel has been made in the application. The prayer is allowed. Let this matter be listed after 4 weeks.
Sir.
None has appeared for the petitioner on call. Let this matter be listed again on 9th of August 2020.
Yeah, please, Your Lordship. Lordship, as per office note dated 2/8, notice was sent to the respondent by registered post on 7/6. Neither AD card nor the unserved notice was received back. And notice sent by ordinary process return unserved without any report from the district judge, Kolkata.
From District Judge Kolkata, what has happened? Without service.
Sir, yes, Lordship, without any report.
PC को तहसील. Heard Mr. JC, what is your name?
N. Karanwal.
N.
Karanwal, on behalf of GC.
N. Karanwal, appearing for Mr. JC Goel, learned counsel for the petitioner. You'd have to take fresh steps. It appears from the office note dated 2/8/2024. How many respondents are there? Only one.
One.
The unserved notices, neither the unserved notices nor the AD card of notices sent to the sole respondent by registered post have been yet received back. Stop. On the other hand, the notices sent to the sole respondent for service through the Office of Learned District Judge, Kolkata, has been received back without any noting on the said blue color file. Without any noting on the said notices. Hence, the petitioner is directed to take fresh steps for service of notice on the sole respondent by usual mode within a week from the date of this order, returnable on 13th of September 2024.
Well, in this case, in IA, we have taken steps, man. And on condemnation petition.
How many respondents are there?
There is mainly one respondent, another is the performer.
Heard Mr. P. Mohanto, learned counsel for the applicant, who has submitted that in pursuant to the directions of this court, the applicant has taken steps for issuance of notice on both the respondents.
Others may not be advocate has appeared by. The name is shown is called this.
On how many respondents are there?
The
Two.
main respondent is one and the another.
On perusal of the office note dated 27/7/2024, it appears that the engaged counsel of respondent number 1 and 2 have filed their wakalatnama in this case. And the name has also been reflected in the cause list. However, none has appeared for the. How many days delay is there?
30 days delay. 30.
We'll give one more chance.
As you lost.
List this matter again on when? 14.
14 May, September.
No, not 14 September.
Others, maybe that. Maybe.
14 August for on for in orders column again.
Mass okay. It's 46 and 47 million.
VC prayer was made, unfortunately, Mr. Singh, I am led by Mr. Singh, the senior
But
counsel.
there is some technical issues there at
Technical issue, yes.
Sonit Post.
So I pray that Lordship may fix it for admission because it has come in orders. As per the last order dated 19/6, service is complete.
Why it has come in orders?
I think because of the office note as far as registered AD is concerned, that part. But the last order clearly says that service is complete. Lordship may kindly fix it for admission on 22nd August if possible.
Third, Mr. What is your name?
A. Gangu.
A. Ganguly, learned counsel for the petitioners. None has appeared for respondent number 1, 2, 3, and 4. Though the service of notice on the said respondents were held to be duly served on 19 by the order dated 19/6/2024. This case shall therefore proceed ex parte against the respondents. Let this case be listed for admission hearing column on
22nd August.
22nd August 2008.
Public. Same order may be passed. There's two connected items, 46, 47.
Same order.
Public.
My lordship, as per the office note dated 29/6/24, a notice has been issued to all the respondents by usual process and by the register post and dusty service. And the dusty service has been received by respondent 2 on behalf of all the respondents on 2/7/24.
Service on all the respondents that you have filed affidavit.
My lordship, we have filed affidavit on 16/7/24, but due to some defective, ma'am, my lordship, it has not been tagged in the record, ma'am.
It has to be. Now, what is the defect?
My lordship, I don't know, but I have the acknowledgement and the affidavit too.
No, you file a defect-free affidavit. Unless it is tagged with the record, how will we know? How many respondents are there?
My lordship, 11 respondents.
Out of 11, Dusty service was in respect of all the respondents,
My lordship,
all respondents.
my lordship.
Learned counsel heard Mr. A. Iqbal, learned counsel for the petitioner, who submits that in pursuant to the directions of this court dated 26/6/2024, the petitioner has effected the service of notices on all the respondents by Dusty mode and also filed an affidavit of compliance to that effect. However, as there was some defect in the said affidavit, the registry has not placed the said affidavit with the case record. for filing an defect-free affidavit within,
My lordship, as per my senior instruction, my lordship, my senior has made this correct, so it is not tagged in the record, my lord, by the registry.
you have removed the defect. Have you removed the defect? You
My,
don't know.
my senior.
The council praised, learned council for the petitioner praised for allowing some time to cure the defect in the affidavit filed by the petitioner. The prayer is allowed. He may cure the defect in the affidavit filed by the petitioner within 7 days from the date of this order. Let this case be listed again after a week on a date to be fixed by registry, along with the affidavit regarding the service of notice on the respondents by Dusty Mode, filed by the applicant. Stop. The registries shall place the said affidavit along with the record after curing of the defect by the applicant, list accordingly after 1 week.
My lordship, stay may be extended.
You are plaintiff or defendant?
We are defendant in title suit.
Then give a fixed date. Let this, instead of 1 week, let this case be listed again on 28th, 2020.
28.
28, 2024. The interim order shall continue till next date.
Mr. Lordship, Lordship, the pro forma respondents, the stakes has been taken and we have filed a affidavit also. So in this manner, all service is completed and main plaintiff oblique respondent one, he made appearance last occasion. But your lordship has instructed that the steps to other respondent also. That was also done through those team mode. In fact, they are only necessary party because in main petition order one rule 10 to page 134, they are not party, but in the High Court, this petition CRP, we have made them wrongly the party. That is why we have taken steps, madam. Now, they have not contested there also. So, but they received the its copies.
2 and 3. How many
Yes.
respondents are there?
Respondents, madam, 2 and 3, yes.
One is appearing.
I'm
for the
respondent number one.
One is the main plaintiff, respondent one, 2, 3 are pro forma, and in but we have also taken steps to them because we make them party in the CRP. And they
What
are
is the
not-
matter? What is the matter?
They have paid for
Striking
they filed a petition for striking out the names of
one and two.
legal heirs of defendant number 1
Before the trial court?
before the trial court as well as defendant number 2. However, Lordship, there is a subsequent order. They have challenged the order dated.
Page 134 is the petition. It
They
is
have
the-
challenged the order dated 34/24, Lordship. This is the order by which their petition for striking out was dismissed, Lordship. However, subsequently, another order was passed on 27/6/24. What happened, Lordship, was that there was a substitution petition for substituting the legal heirs of defendant number 1. But that petition was only disposed of on 27/6/24. So the striking out petition was disposed of previous to the order by which the substitution was allowed. So I may be allowed to file an affidavit by to bring on record this order, Lordship,
My lord,
because this is important for adjudicating this case, Lordship.
one points, my lord, order one road 10,
Service is complete.
yes.
Service is complete.
My lord, shortcut may be given because form
Let,
50,
let him bring on record that order.
Yes, Lordship.
1 week, my lord, because at any stage, this honorable court also take the, if they feel necessary, strike off, because their land is different. Builder is same, that is why make the same person. Now they are suffering because pendency of the suit in lower court, the form 50 is not allowed. Now they take a loan on for several months they are with. So their land is different. They have no any relief from this petitioner.
Lordship, actually, the
So this
substitution.
is the thing, and we can
One
take
by
this.
one.
Plaintiff has only grievance against the respondent number 3, not 1 and 2. 1 and 2's land is separate. Their boundary is separate. They want a road which is the belongs to respondent defendant number 3. So defendant number 3 will contest with the plaintiff, no problem. But defendant number 1 and 2, now they say that we are suffering because pendency of the suit. They have no relief, nothing. If your lordship go through this schedule of the 3 cell deeds, it shows that the defendant number 1 and 2, that is petitioners here, their land is different. They are no boundary man of the respondent number 1 of the plaintiff. So this pendency of the suit make them problem, cause them problem. That is why striking. But this impugn order said that at this stage I cannot understand or whether it is striking. That is why I for CRP is filing.
Lordship, I may
So
be allowed
hearing may
to,
be taken, but till then the plain may be exchanged because there's they are prejudice of this order. So a short date may be fixed. Till then we exchange the pleadings if so desired.
Heard Mr. M.J. Borua, learned counsel for the petitioner. Also heard Mr.
BS Dekha, Lordship, BS Dekha.
B.S. Deka, learned counsel for respondent number 1.
Respondent 1 and plaintiff. He is the plaintiff. He is
Respondent
contested.
number 1. Learned counsel for the petitioner has submitted that the petitioner has filed an affidavit of
No, respondent.
who has filed the affidavit?
Respondent 1.
No,
No.
this affidavit of Dusty.
Dusty.
Or Dusty or the 2 and 3.
Affidavit regarding service of notice on respondent number 2 and 3 as directed by this court, which is accompanied by a copy of notice wherein the signatures of respondent number 3,
2 and 3 at 3. because
2 and 3 are appended thereto. Stop. Considering the affidavit of compliance filed by the petitioner, it is held that the notices are duly served on respondent number 2 and 3. Stop. Then it counsel for the respondent number 1 has prayed for some time for bringing on record the order dated
27/6/24.
27/6/2024 passed in
Title suit number 58/19.
title suit number 58/90,
19 by the learned trial court.
58/19 by filing an additional affidavit. The prayer is allowed. The respondent number 1 may file the said affidavit within a week from the date of this order, with a copy of the same furnished in advance to the counsel for the petitioner. Let this matter be listed for admission hearing. When do you want?
10 days after 10 days.
Lordship, in the
Because they are suffering for death. Simple
third week
matter.
of August, I won't be available from.
Suggested date.
That today is the 14 or before 15.
Lordship, I won't be available
12,
between
13, 14.
12 to
Suggested
14.
date.
So on 20th
30,
of August.
20 August.
That's better. They are suffering, that is. Before that, 19th November, if possible, before.
20 August.
Always.
Yes.
Lordship, something is completed, Lordship, it's completed. Opposite filed IA for vacation of stay, Lordship. They served a copy to us.
What is this? No, this is a CRP. IO.
Yeah.
Service is complete.
Lordship. They filed the IA for vacation of stay, Lordship.
No, have you filed affidavit? Of the, you were allowed to take steps by Dusty mode. No, what day? This is a, what is your name?
On behalf of JL Ashkar, my name is J.M. Sulaiman, Lordship. I'm on behalf of Advocate JL Ashkar.
You have not taken steps for service of notice. The stay would be vacated.
No, Lordship.
You have not
If-
taken. You take step, I am vacating the stay.
I'm on behalf of another advocate,
No,
Lordship.
no, whatsoever may be reason, but when interim relief is granted to you with a direction to send notice to the other side, and you have not taken any steps even after 1 month.
I'm not in this case, I'm on behalf of Lordship. Can be.
Only usual mode you have taken steps. Okay. Third, Mr.
J.M. Sulaiman.
J.M. Suleiman appearing on behalf of Mr. J. Laskar, learned counsel for the petitioner. It appears from the office note that though the petitioner was permitted to effect the service of notice on the respondents by Dusty mode. However, the petitioner has not yet taken any steps for the same. It appears from the office note that petitioner has only taken steps for issuance of notice through usual mode. Stop. The petitioner is again directed to take steps by service of notice on the respondents by registered post with AD as well as through Dusty mode within 3 days from the date of this order, returnable on 13 September 2024. If you don't take steps this time, the stay would be vacated. The interim stay granted earlier shall continue till next date.
May plead your lordship. In this case, lordship, notice of motion issued on 15/7/2024, lordship, and directed to list the matter after 4 weeks, lordship. Although 4 weeks is not over, lordship, matter is listed because my learned friend perhaps mentioned the matter, Lordship. So in this case, Lordship, they have filed one affidavit, Lordship. Although there is no provision to file affidavit in CRP, if there is any some Lordship, Lordship, they have to brought some new materials, Lordship. That is not their Lordship. They have filed one affidavit with some allegation, Lordship. So I want to file reply of that affidavit, Lordship. I need 2 weeks time, Lordship. They have brought some allegation against me in the affidavit, Lordship. They have not brought before this honorable court any new facts, Lordship, in the affidavit. So 2 weeks time may be granted, Lordship. In the meantime, Lordship, I will file affidavit, Lordship.
My lord, in fact, there is no new ground, my lord. I think my learned friend refers to the divorce petition, my lord. Where, my lord, they are.
This is a husband-wife dispute.
Yes,
Yes,
my lord.
Lordship.
Yes, my lord.
So cross of PW 1 and 2 were closed, Lordship. Against that, I have preferred the present revision petition, Lordship.
Neither ED card nor unserved notices sent to respondent received back.
But this,
The-
service may be allowed.
Okay, the appellant is directed to take fresh steps for issuance of notice on the respondent number 5 by by usual mode as well as by registered post with AD. The appellant may also take steps for effecting the service of notice on the respondent number 5 by Dusty mode, and thereafter file an affidavit of compliance to that effect. The appellant shall take steps for issuance of notice within 7 days from the date of this order, returnable on
28th of August, my lord.
no.
20. My lord,
Will it be possible?
my lord, yes, that's the service Guwahati, my lord. My junior will go there, my lord, and serve it, my lord, personally. And take acknowledgement receipt, my lord. Thereafter, we shall file affidavit, my lord, on that count. Because this is a very.
20
petty issue,
August.
my lord.
Okay,
Yes.
20 August
Yes,
2024. List according.
I am obliged. my lord.
None appears for the petitioner on call. On last occasion also, that is on 31/7/2024, nobody had appeared for the petitioner on call. This interlocutory application is accordingly dismissed for non-prosecution.
Now, this IA is filed, my lord, against the order of the, my lord, this honorable court, my lord, because, my lord, ex parte order was passed, my lord. Delay was condoned in the court of the, in the court of lower court below, my lord. And it was followed by, my lord, the honorable high court's order, my lord. Kindly peruse your lordship, that order, my lord, annexure 1, page 10. Earlier,
Now, for what purpose this IA is filed?
I am for vacating the stay order, my lord, interim order. Because delay was condoned in the lower court below, my lord.
Stay is in means CRP.
Yes, my lord. Sir.
What was stayed?
State, my lord, delay was condoned in the lower court below, my lord.
Who filed the civil revision?
We filed the CRP.
What
No,
was-
now this CRP is filed by my learned friend.
What was the grievance? Yes, Mr.
May I please the lordship, my lord? If your lordship will peruse the earlier order of the honorable court, my lord.
No, you answer my queries.
My lord,
Why this CRP was filed?
Mr. CRP was been filed because challenging one of the order of the
Order dated?
consideration of the injunction, my lord.
Okay, okay.
Condonation, my lord. That is annexure 2, my lord. In the
Condonation for what? Condonation of delay in filing.
injunction, that may appeal, my lord. They have filed an appeal before the civil judge for condonation of delay, my lord. And which was being
No,
allowed.
no. In the trial court, who was the plaintiff?
In the trial court, my lord, they were the
They were the
plaintiff,
plaintiff,
I am the
defendant.
defendant.
They also filed an injunction petition
Yes.
there.
No, no, we filed in.
You filed an injunction petition. What happened to that injunction petition?
Expanded.
Injunction was allowed, my lord,
Allowed,
allowed,
ex parte.
expert.
Then they filed,
Hearing both the sides, my lord, it was allowed.
okay.
No, both side, not both side. Ex parte order passed. That's why we filed appeal. Whatever is done.
On facts, at least there should not be dispute.
My lord, oh, the whole things comes there,
No, let me understand.
my lord.
Your injunction petition was allowed. Then you filed an appeal against that injunction. Order 43 rule 1R.
Yes, my lord, we
Before
filed.
the
That
civil
was
judge,
dismissed.
civil judge.
Civil judge, my lord.
That was dismissed.
Dismissed, my lord.
Thereafter,
Thereafter, we filed my lord, CRP before dishonorable court
against that
And-
dismissal order.
against the dismissal order. And
Then why
thereafter,
this
this my lord,
in the CRP, a stay was granted.
in the CRP, my lord, this order was passed, my lord, dishonorable court, my lord, dishonorable court passed that there is a option whether you file under order 43 rule 1R, you have to file the appeal, my lord, before the civil judge senior division. We file accordingly, file the appeal. There was some delay has been condoned. That's why he has filed it. But that ex parte order was filed during full lockdown time, my lord, 19/3/23, full lockdown time. That was ex parte order. Without my lord considering the petition itself, my lord. Order 13 rule 2 petition was not considered. Interim order passed, my lord. That is that in ex parte order was passed, my lord. In their petition, page 27, my lord.
No,
Nah.
just a minute.
In my IA, your lordship, my lord, because this order has been passed, page 10, my lord.
You are the respondent in this case.
Yes, my lord, I am the respondent. Page 10, my lord, in IA.
Just. The trial court granted issued direction to maintain status quo.
Yes,
Against that status quo order, you filed a petition for vacating status.
May I submit it, my lord?
Yes.
My lord, whole facts comes, my lord. He is a plaintiff. He is a plaintiff. And he filed the suit. And the suit is dismissed. Once the suit is
Which suit was dismissed?
suit, my lord, may I take a lordship, my lord?
Suit number?
My counterclaim is going on. I have three,
No, suit
the-
was registered as title suit number 17.
this is the order, my lord.
17, 2018.
This is the order.
That was his suit.
Yes, my
Where you filed a written statement along with counterclaim.
counterclaim, my.
Suit was dismissed.
May I take a lordship that my certified copy is there? Page number 1 is, that is a judgment is awaiting in the Barpeta, my lord, in Bozali. And second is also for argument, which has been awaited. And that judgment is required, counterclaim judgment is required for the decision of this case. And third page is there, certified copy, where your lordship will be transparent, my lord. So counterclaim judgment is there, his suit is dismissed. So he's coming before this honorable court, hunting his injunction order, for which allowing the injunction order by the appellate court has been filed CRP, where CRP interfered it, and he has filed interlocutory application for modify vacating of that stay order. And for proper education, earlier court also has adjourned the matter for getting the judgment from the trial court, which is awaited. So I have also submitted. Next day is on 30, my lord, 30 August. So let the matter be adjourned. And on 2nd September or 3rd September, it may be fixed after getting that judgment for the proper education of the CRP Malay.
Or we have already filed, my lord, restoration, my lord, dismissed for default, my lord. Lanet also did not appear, my lord. This restoration petition along with the
Because
confirmation.
your suit,
Yes, my lord.
what has
Because
happened?
counter, my lord, his counter.
No, what has happened to that?
Because Lanet counsel who was conducting the case in the Lanet trial court below did not appear
Understood that your suit was dismissed,
for default.
default,
Yes,
and
ma'am.
you filed a restoration
Restoration,
petition.
yeah.
What has
And
happened to
notice
that?
issued, my lord.
It is in
Already
the
notice
notice stage.
proceeding has been stayed, all proceeding has been, last it was on.
Proceeding has been in the restoration petition.
Yes, my lord.
Because of an order of this court.
Yes, this court, my lord. 2nd August, it was fixed, my lord.
My all certified copies here for your lordship, my lord.
Last fixed on
that is
2nd
true.
August.
As the earlier court has also adjourned the matter for the coming of the judgment of the counter claim, which has been awaiting for the judgment.
But the judgment cannot be
And
passed. my lord, because this-
2/8/24, where the trial judge, I have called the certified copy, has fixed the matter for judgment, 38/24 for judgment.
But as this petition has been filed, my-
And this court has, that is, my CRP has stayed the proceeding of the appeal. Not it.
Not appeal.
all.
Miss case.
Yes,
Yes.
yes, that is. So his title suit is dismissed, my counterclaim judgment is awaited, and the trial judge which is there from this Munshi Bojalina, district and session judge, where is absence. So on 2/8/24, the order has been passed, awaited for the judgment. So 38/24 for judgment. So I pray before your honor, lordship, my lord, that the matter may be adjourned. 38/24, the judgment is awaited. With that judgment is very much necessary for the proper education of this matter. my lord.
Notice issued, my lord, service has not completed, that is why it was listed. 2nd August, my lord, the trial court below. I have.
No, if the suit is restored,
Yes, my lord, then.
then it may affect the outcome of counterclaim also.
My lord,
We are, this is in the orders column today.
yes,
The service is complete.
Only one part. I am.
where I submit the certified copy, where it says that 2/8/24, the matter was taken up and defendant are represented, present in person, fixed 38/24 for the counterclaim judgment, my lord.
Whether any records would.
But I have
necessary-
given certified copy, my lord. So till then, the matter may be adjourned. Let the judgment comes of my counterclaim, and in the meanwhile,
No,
if his suit is restored, he has made a submission. If his suit is restored, let that be also matter come. Till then, it may be adjourned matter.
No records were called for. Whether records would be necessary.
Necessary, my lord.
My lord, why record will not be necessary? His suit is dismissed. And he says, submit before this court that I have filed a restoration petition. I have submit my certified copy. That suit is dismissed. My counterclaim is for judgment. Now he submits that his suit has been filed for restoration. And how far he submits the certified copy, I don't know. But my counterclaim judgment is awaited by the session judge. And
All-
that is the certified copy I have placed before this honorable. In the earlier occasion also, the lordship has also stated the matter for awaiting that judgment today. I was also expecting for getting the judgment, but the learned conducting council of the Bajali had made this certified copy supplied to me, and same has been produced before your lordship by lord, where it says that counterclaim judgment will be delivered on 38/24. Till then, this CRP or his counterclaim, whatever may be modified, whatever his IAS petition may be adjourned, let the judgment
Why
come.
this misappeal 2 of 23 was filed?
Yes,
Who-
my lord.
Who filed this?
Yes, my lord. We filed this case, my lord.
Why?
Because against the order of this, my lord, injunction order, my lord, as ex parte order, my lord, we filed this case. Page 85.
And there was a delay in filing that,
Yes, my lord.
and the condonation delay petition was dismissed.
Dismissed, my lord.
Against that dismissal,
We filed here.
this CRP has been filed.
Yes. The page 48.
No, against that dismissal, who filed this CRP?
We filed CRP. Because our misappeal was
You are appearing for Devananda Padgiri.
Chakrapani Padkiri, my lord.
Then you are respondent in this case.
Here in this case, I am respondent.
So what I am asking about this civil division
Oh,
petition.
yes.
Who has filed?
We have filed.
You have filed.
Yes, my lord.
Why you have filed?
Because, my lord, considering I have filed the petition, my lord, because the landed motion 38/20, where it says, my lord, that the order dated 4/8/23, where it was been considered by the trial court for condoning of delay of 1058 days, has considered by making 99 days. That is 13/8.
Delay was condoned or not?
Delay condon and along with the 2000 cost, my lord.
Okay. Against that condonation of delay you have.
Yes,
my lord.
Then that.
Yes, my, against
Then-
that order, this revision has been filed, my lord.
So it
That is page 12, my lord, in my eye.
heard Mr. A.D. Chetri, learned counsel for the petitioner. Also heard Mr. H. Das, learned counsel for the sole respondent. It appears then this
It was followed by Honorable High Court's order, my lord. Delay has been found.
this
Annex 2, page 12.
Nijje case number
6.
6 of 23 would be necessary.
Hmm.
Record of Nijje case
Yes.
number 6 of 23,
Yes, my lord.
where delay was condoned.
Yes.
Along with the petition.
Let this case be admitted for hearing. Let also the Nijje case number 6/2023, which arose out of misappeal number 2 of 23, be called for from the court of learned civil judge,
Bojali, Civil Judge Bojali Patshala.
civil judge Bojali Patshala. Let this case be. When do you want it?
My lord, after judgment, it will come on 30, my lord.
No, it has
September.
no relationship with the judgment.
Then, my lord, it may come on 2, 3 or 5, 6, my lord, September, my lord.
Okay,
Okay, my
let this case be listed on
lord.
3rd of September for admission hearing.
Title appeal is, my lord, mentioned as PA. That is mentioned, mid-J along arising out of PA 2/23.
Down.
page 12, page number 62 in his petition.
Miss appeal, not title appeal.
Miss appeal, file.
Miss appeal 2 of 23.
But here I have seen.
Miss
TA,
appeal.
TA number 2/23 against the order that is so and so.
How it can be title appeal? Because you have preferred an appeal against order.
It will be miss appeal.
Yes, but here it is mentioned wrongly. Now, this impugn order, my lord, order is, my lord, page, his impugn order is page, my lord, 62. Annex 12.
$62.
No, it is not TA, it should be miss appeal, because that is for condonation of delay only,
Yes, my lord.
Yes.
list accordingly. We will consider the interim application along with the name.
Interim order is that it will continue.
The interim order shall continue.
The matter is fixed on September.
Heard Mr. H. Das, learned counsel for the applicant, also heard Mr. K.D. Chetri, learned counsel appearing for the opposite parties. Since the connected civil division petition number 18/24 has been fixed for admission hearing, on which date endeavor shall be made to dispose of the said case on 3rd of September. Let this case be listed along with the same on 3rd of September. The interim order shall continue till next day.
Record of miss
That direction.
Already.
sir.
that direction. With all respect, my lord.
I have less.
Right.
May I please, Your Lordship, we have filed appropriate application for withdrawal of Bakalat number.
Why, what for this interlocutory application?
Lordship, for withdrawal of her Bakalat number.
Withdrawal of wakalatnama.
Yes, madam.
Have you informed your?
Yes, my lord. Annexa 1, my lord. We have sent a registered letter. We have not received any instruction from.
Whether the notices were
Yes,
served
I have checked, my lord.
in the
Delivered.
track consignment report.
Consignment report,
Where have you checked?
yes, checked and it's already delivered, my lord.
No, from where are you saying that it has been delivered?
From,
Track consignment
yes,
report.
ma'am.
You give a copy of that printout of track consignment report. Then we'll close it today itself. Give your consignment number to Sudhir. Consignment number option or track consignment report at our law. You have nothing to say? You are?
I am for 1, 1, 1, 2, 1, 3, and 2 respondents.
Heard Mr. Heard Mr. S. Hound,
I am estimating.
DJ Medhi, learned counsel for the applicant. Applicants. Also heard Mr.
C. Sharma, Lordship.
C. Sharma appearing for
1, 1, 1, 2, 1, 3, and 2.
respondent number 1A, 1B, 1C, and respondent number 2. This interlocutory application has been filed by respondent number by the
Petitioner.
applicant under order 3, rule 4 of the Code of Civil Procedure. What is order?
Determination of the appointment of one.
Which rule? Order 3, rule 4, sub rule? Taking leave of this court for determination of the appointment of counsel for the applicants. Now, what is the requirement of this rule? Which,
Lordship, no pleader shall act for any person in any court unless he has been appointed for the
where are
purpose.
you reading? Which is of your help? Which helps you?
Lordship, appointment of pleader.
Section.
One, sub-rule 1.
Read it.
No pleader shall act for any person in any court unless he has been appointed for the purpose by such person by document in writing signed by such person or by his recognized agent or by some other person duly authorized by or under a power of attorney to make such appointment.
This part is over because you were engaged.
Lordship.
So you are entitled to appear on behalf of the applicants. Now, withdrawal, which part is helping you?
Lordship, rule to every such appointment shall be deemed to be in force until determined with the leave of the court by writing signed by the client or the pleader as the case may be and filed in court until the client or the pleader dies or until all proceedings.
Now,
in the
this you have to explain. Read it again.
Every
such appointment
appointment
shall
be deemed to
shall
be in force.
filed in court shall be for the purpose of sub rule
1.
deemed to be in force until determined
The
with
leave
leave of the court by writing signed by the client or the pleader.
Pleader.
Here client has not signed. Pleader as the case may be. And filed
in
or
court.
until the client or pleader dies. So this portion you are relying
Lordship,
that you are seeking leave of this court
Lordship.
for determining the
Appointment of the
appointment of the leader.
leader.
बेटा क्या लिखा? Not SK count.
DJ meeting.
DJ meeting. Learned counsel for the petitioner has submitted that in this case, by order dated . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . 9/9/2022, notices were issued to the respondents and respondents. However, the notices on respondent number 4 to 7 could not be served and same returned without service. Thereafter, comma, by order dated 21/2/2024, the Lavajima Court directed the applicant to take fresh steps for service of notice on respondent number 4 to 7. And stop. It is submitted by learned counsel for the applicant that the engaged counsel thereafter requested the applicants over phone to provide the correct address of the respondents. But till date, the applicant have not responded to the request made by the council and failed to take any steps in that regard, or neither any further instructions have been given by the applicant in that regard. It is further submitted that by learned counsel for the applicant that thereafter, on several occasions, this court directed taking of steps by the applicant. However, the applicant did not made any response to the request of the learned counsel to that effect. Stop. It is submitted by learned counsel for the applicant. How many applicants are there? Applicants that under such circumstances,
9.
the council has decided to withdraw his wakalatnama from the said case, and accordingly on 4/6/2024, the applicant wrote a letter to joint registrars within bracket judicial informing about what is this 3/6 letter?
Lordship, we have sent a registered letter to them to
Informing about the letter dated 3/6/2024 sent by the council for the applicants to the applicants, informing about their intention to withdraw from the said case. Learned counsel for the applicants has also submitted a copy of track consignment report of the letter sent to the applicants. And on perusal of the same, it appears that the letter sent by the counsel for the applicant has been delivered to the addressee on 8/6/2024 against consignment number RS 602-161126 IN. Under the above circumstances, the application for the withdrawal of wakalatnama by the counsel for the applicant is allowed and allowed and the engagement of who were the engaged counsel? Names?
I am DJMAT.
Only one.
I am, yeah, MS U Borua, Usha Borua, and S Khan.
Mr. DJ, engagement of Mr. DJ Medhi, Miss U Borwa and
S Khan,
Miss
Mr. S Khan.
Mr. S. Khan is hereby hereby allowed to be. No, can be the last name. Hereby determined. Engagement of so and so as the engaged counsel for the applicant is hereby determined under section, under order 3, rule 4 within bracket 2 of the Code of Civil Procedure. The registry shall strike out the names of the aforesaid counsel as the engaged counsel of the applicants and shall not show their name in the cause list henceforth. This interlocutory application is accordingly disposed of. List the for what the other CIA is there. List the CRP number 99/2022 with IA number 2722/22 after 2 weeks from the date of this order.
Much.
May it please the Lordship. Lordship, this matter has been listed for the first time. Notices.
58. What for this IA is there?
I is for condonation of delay in filing
Third
the.
Miss P. Bothakur, what is your name? Third Miss M. Soikia, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 has been filed by the applicant for condoning the delay of 166 days in filing the connected miscellaneous first appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within a week from the date of this order, returnable on 24th of September 2020.
Oblige, Lordship.
None appears for the appellant on call. Let this matter be listed again after a week on a date to be fixed by registry. Finish. Finish.